Starting. All attendees are in listen-only mode.
Good evening, everyone, and thank you for joining us this Wednesday, September 17th, 2014. My name is Frank Boquicchio, and I'm a partner at Vincent Russo & Associates, and I'll be hosting tonight's webinar, which is entitled Keeping It Simple, Elder Law 101. Before we begin, I need to address a few administrative items. The presentation will last approximately 1 hour, and during this time, I'm sure you'll have some questions. You can type your questions at any time using the question pod, which is located in the lower right-hand corner of the screen. I'll try to address as many of the questions as we go along, but we'll also leave time at the end of the program for Q&A. No question is unimportant, and we'll answer as many questions as time permits. Please note that we'll be discussing financial and legal matters, and this program is not a substitute for obtaining professional financial and legal counsel. There's the disclaimer. At the end of the presentation, you'll see our contact information. Please feel free to contact us with any questions related to the material covered tonight or any other questions that you might have. Finally, after the presentation ends, you'll see a survey. Please take a few minutes to answer the survey questions. Your feedback helps us develop and improve future webinars. Thanks again for joining us, and we are off and running, that is. So what we're going to cover today, this is kind of just a brief overview of the presentation tonight. The 4 must-have legal documents, planning for long-term care, in particular Medicaid, but not only Medicaid, as you'll see in a minute. How to protect the residents, how to protect your life savings, which is basically liquid assets. And then we have our spotlight, which is our special guest, Susan Melise. Susan's here.
Thank you. Thank you for joining us this evening.
Thanks, Susan, for taking time out of your busy day, especially in the evening on this beautiful day. It was nice today.
Beautiful.
Holy mackerel. So Susan is going to talk about long-term care insurance and all the great things that she can do to help people protect their assets as well. So we're going to save the best for last, and we'll have her chime in towards the end of my presentation. But I've told Susan that if she's got anything to add during the presentation, to feel free to throw her 2 cents in or ask questions or whatever it is.
Okay, thank you, Frank.
Good. Dialogue is good. All right, so let's jump in. All right, so the 4 must-have legal documents. This is kind of everybody over 18 needs to have these, what I'll call basic legal documents, without exception, except, well, that's not true. I shouldn't say without exception, because there are certain people who just can't sign these documents for one reason or another, and we'll talk about what. So basic, all right, we're back. I may have to move the mouse every now and then so it doesn't go to sleep. Sorry about that. So the 4 basic documents: adorable power of attorney, healthcare proxy, living will, and then, of course, a last will and testament, or maybe a living trust, depending on your planning. So let's get into, no, wrong one, sorry. So let's get into a little bit of detail. The way I like to explain the documents, I usually start with the healthcare proxy because I think that's the simplest document conceptually. It is what it says it is. It's for healthcare decisions. So you sign a healthcare proxy, and you're appointing somebody to make healthcare decisions, but that person can't make decisions until you can't make decisions for yourself. So you're not giving up any power when you sign a healthcare proxy. You're still in control. It only takes effect if you become incapacitated. And it covers every healthcare decision from, as minor as pulling a tooth to as significant as end-of-life decision-making. If you have certain wishes about the end of life, which is the quote-unquote pulling the plug, sorry to be so blunt, but that's how most people are familiar with the term, that's the living will. So if we're going to say one of these is optional, it would be the living will. And the question basically is, if you were in a vegetative state or brain dead and there's no reasonable hope that you were going to get better, would you want machines to keep you alive, or would you rather just be kept comfortable? So you can outline those wishes in a living will. And then the durable power of attorney basically is supposed to cover everything else. So talking about financial matters, bank accounts, investment accounts, your house, something that might require your signature. And the power of attorney can be as broad or limited as you'd like it to be. You can give your agent, which is the person that you pick, as little or as much power as you like. As a planner, we like to see the power of attorney basically have unlimited power. So that means it's a very powerful and important document. So you have to make sure that you pick the right person or persons to be your agents. Just a word of caution, because one of the things that we do when we meet with clients, especially new clients, if they have documents, is review them to make sure that they have all the right provisions and that they're done properly. The caution is that, excuse me, on the healthcare proxy, you can only name one person at a time. So if you've got a healthcare proxy, take a look at it. And if you've named your kids or together or separate or something like that, you're gonna want to redo it because you're really only supposed to have one person at a time. On the power of attorney, it's different; it's more flexible, but healthcare proxy, no. And then when we pass away, our will may take over depending on what our assets are, how they're titled, and the other three documents are no good. The power of attorney, the healthcare proxy, and the living will die with us. I just had a conversation with somebody yesterday whose mom unfortunately passed away on Monday rather suddenly, and she asked if she can go to the bank and use the power of attorney to pay the bills and do other things, and I said, no, you're not the power of attorney anymore, unfortunately. So that's when the will is going to take over, or if there's a trust involved. And basically what I like to say here is when you do a will, you're deciding who gets it, how they get it, and when they get it. All right, you're not leaving it to chance.
Yeah. Frank, I have a question for you because this is often when we are on this topic with my clients in the home, they ask me these questions. Now, can these documents, quote unquote, expire, or what would you suggest would be how many times you take them out of the vault, the drawer, the hiding place, and you review them?
Or wherever they are, right. No, that's a great question because that does come up a lot. The general answer is, at least speaking from our standpoint, the way we prepare, what I tell my clients is I draft the documents ideally to last your lifetime with two exceptions. One is a change in the law and one is a personal change. And I don't have control over either of those two, obviously. But having said that, that doesn't mean that you should just stick them in a drawer and forget about them. So they don't go bad. You can actually put expirations on things like healthcare proxies and powers of attorney. I don't think I've ever done that in 20 years, but you can. So they're good for your lifetime unless you revoke them. But it's a good idea to update probably every couple of years, or at least to look at them. One of the big changes that came around in 2010 in New York was the power of attorney law changed. But what happened was they grandfathered, quote-unquote, grandfathered the old power of attorney. So if you had done a power of attorney in 2008, just because the law changed in 2010 doesn't mean you had to do a new one.
Okay.
But if I had done a power of attorney for somebody in 2008 and now in 2014 they're coming in to review their planning, I would say, you know what, we should update it because it's 6 years ago, the law has changed. Their old one is still good, but it's stale, basically.
Mm-hmm.
And will's the same thing. A will is it's designed to last until you die, but obviously you can change it anytime you want.
Mm-hmm. Mm-hmm. Another question, if you want to, and you can address it later, is that believe it or not, clients that I do meet, we get on this topic. Do you have these documents set up? Because I do ask that question, and a couple will say to me, "What do I need a will for?"
Yeah. That's
what
a
I
hard
have goes to one, and one
right,
goes to the
exactly.
other.
That's why
what do I need one?
That's why it's a hard question to answer
Mm-hmm.
because the blanket everybody should have a will is true. But I would, if I'm being honest, I would say that wills are more important for some people than others. So the married couple is the perfect example. If everybody, and obviously we don't have a crystal ball that knows what's going to happen, but if I have a typical married couple where they own everything together, and if they did a will, it would say, well, I leave everything to my wife. Well, what do I need to do a will for? Because if I die and she's on as beneficiary, we're on everything together, it's going to go to her anyway. And that's true. So I think that depending on what the other goals are would determine whether or not I'll say, of course, that they should have a will, but there might be other things that are more important than doing a will, certainly. So when I meet with clients for planning, whether it's a new client or an existing client, I usually break it down into two things, the things that you should do and the things that you could do. So those first four, the power of attorney, the proxy living will, the will, are things that you should do.
Right.
But if somebody gives me that response, well, do I really need a will? I said, no, if you don't want to do one, I would understand. You still need to do these other things, and that's fine. Mm. But just understand that you may have to revisit that later.
Yeah.
And changing wills, too, because you can do, at somebody who's 40 years old with little kids is going to have will provisions in it that make sure that the kids are protected in case something that happens. If I'm meeting with a couple who's 60, 70, 80 years old, they're going to have a different focus. They're going to be more concerned about, long-term care or nursing homes. So the wills aren't going to be the same, obviously. And the will that you did 30 years ago probably needs to be changed because your focus has changed.
And definitely for younger couples who have special needs children.
Yeah, we can put
I
protection
had
in there.
that conversation where they don't have a will, and I'm going, you have to have a will for
Yeah.
a special needs situation in the family.
Right, and that's going to be one of those where it's not going to be, you know, all right, I understand if you don't do a will. No, that person needs to do a will. All right, so some long-term care comments, I guess. Who pays for it? Medicare is very limited in terms of long-term care. So anybody out there who has Medicare, has a family member who has Medicare, may have been through hospitalization and rehabilitation, probably knows that Medicare could cover up to 100 days of rehabilitation or skilled care. But that's it. Medicare is not meant to cover long-term nursing care. Long-term care insurance, of course, which we're huge proponents of in the right situation. So Susan's going to talk about that because she's the expert here tonight. Paying out of pocket, of course, but most people don't come to Susan and I so that they can just say, well, I'll just pay for the nursing home if I get sick, to the tune of, you know, $15,000 a month. Children or other family members, I mean, it's probably a bit of a stretch, but, you know, if you've got somebody in the family who's wealthy and is willing to pay for your care, I guess God bless you. And then, of course, the government, which is going to be the Medicaid program, which we'll talk about in a little bit more detail. So one of the things that some people are concerned about, especially when we talk about Medicaid, because Medicaid is a program for people of limited means. It's not meant for people who have assets or high income. So, you know, every now and then I'll get the comment about, well, you know, is the Medicaid care going to be good? You know, am I going to get sufficient coverage? And the short answer is yes. I mean, that's especially in a nursing home. It doesn't matter if you walked into a nursing home, you would not know just by looking around who's the millionaire paying privately and who's the person that's on Medicaid. The care remains the same, whether it's a private pay or Medicaid. In home, same thing. If you're getting care at home and you're going through an agency, then they're going to send you an aid, and either you're paying privately or going to get Medicaid coverage. It's not going to affect the level of care that you get. And then long-term care insurance, Susan's maybe disagreeing. So, and that's probably where the long-term care insurance is going to become helpful.
Well, if you enter into the system on Medicaid for home care, the system is going to dictate who they're sending there to take care of you. If you're receiving home care and you're in charge, either through your own personal resources or your family stepping up to the plate and helping to pay for the cost, or through long-term care insurance, then you're in charge of who you're hiring to come in and take care of you or your family member. So it's not that Medicaid would serve you less, it's the fact that there's not choices.
Right, I think that's the point. You're right, and I stand corrected. You're right. So what I was thinking is if I have somebody who comes in and is getting care at home and is going through an agency and is getting care, and that agency also accepts Medicaid, then I don't think if they switch over to Medicaid that there's any real difference. I think you're right, though. If you're privately paying or if you have long-term care insurance, which in essence is privately paying, you can have a broader number of people or agencies even to choose from and be able to pick and choose better who you want as your caregiver, right? So you're right. And of course Medicaid, the one big point I want to make here on the slide is for Medicaid home care there is no look-back period, which comes as a great shock to most people when I tell them that, because most people have heard about this 5-year look-back rule, but that only applies to nursing home care. It does not apply for home care. So if somebody has assets today, September or whatever I said it was, 17th, and they were looking to get help at home, we can divest them of those assets sometime in the month of December, and if October 1st rolls around and they're under what Medicaid allows, which is currently $14,550, then they can apply for Medicaid as of October, even though they gave away money in September. All right, so there's no look back for home care. That's a pretty big one. Excuse me.
But there's still asset and income requirements.
Yes.
Okay.
Bingo. Right. So if you are if you're applying for Medicaid, that's right. There are going to be asset and income restrictions, whether it's home care or nursing home care. The asset restriction is basically the same. It's $14,550. I may say 14 during the course of the evening because I like to round things off, which is easier. So it's basically $14,000. But at home, the income, which is the problem usually, because what I like to say, well, not that I like to say, but I think it's accurate. When I talk about home care or community Medicaid, I like to say often that it's nice in theory but difficult in implementation. So in theory it's simple, get rid of your money and apply the next month. But in reality, the problem with that is the Medicaid says that everybody can live on $800 a month. 829 is the real number. So I don't know about the rest of New York State, but on Long Island that's very difficult to do, if not impossible. So if I've got somebody who's got even $1,500 a month in income, Social Security, which is not a lot, and Medicaid's right, Social Security or a little Social Security, a little pension, $1,500, and Medicaid says they can only keep 8 of it, that extra $700, extra according to Medicaid, is called the spend down, and Medicaid would look for them to spend that $700 on their care, which means they're living on $800 a month. So the solution to that, which is wonderful, is called a pooled income trust, and you see it on the slide there. It says protect your income. To me, this is potentially a lifesaver, not literally, but being able to keep people home longer, because everybody wants to stay home longer and not end up in a nursing home. The way it works is, if I have in my numbers, so the person has $1,500 a month of income, and Medicaid only lets them keep 8, so they have a $700 a month spend down. Instead of spending that $700 on their care, in which case they're literally living on $800, they can take that $700 and put it into what's called a pooled income trust. The Teresa Pooled Trust that you see there is just one of about 15 or 20 in New York State. They're all conceptually the same. They're all established by charities, and they're all managed professionally. And the idea is, and it may sound a little funky, but it works, Medicaid will let you put that $700 or the spend down into the pooled trust, and then you can submit your bills, so your LIPA bill or your phone bill or your cable bill, or if you have rent, your real estate taxes, you can credit card, you can submit those bills to the trust, and they'll pay your bills with your $700 minus the little bit of fee that they take out to do it. So you get, in essence, in that scenario, you get to keep the $800 to live on. You get to use almost up to the full $700. So you're getting to still use almost all of your income and get Medicaid to pay for the care. So sounds too good to be true. There are 2 catches to it. One is that if there's any money left in your account when you come out of the trust, and there are 3 ways you would come out of the trust. One would be if you make a miraculous recovery, which is not typical, and you don't need Medicaid anymore. The other is if you pass away. And the third would be if you end up in a nursing home, because these pooled trusts don't work in nursing homes. So if any one of those 3 things happens, any money that's left in your account that you're putting in the $700 goes to the charity that set up the trust. So that's the trade-off. It doesn't come back to your family. If everybody did that, because what I would like to see happen is that my clients put in the money and use it every month so that there isn't money left over. If everybody did that, then when everybody died, there would be no money to go to the charity. So why would a charity want to do this? They wouldn't. So the other catch, if I could use that word, is the initial deposit has to be doubled. So my example, instead of putting $700 initially, you put in $1,400. The trustee will take $700 and set it aside as more or less security. And then when the person passes away or comes out of the trust, they're at least going to get that $700 and whatever's left in the account, if anything. So if you used all of the account, then there's nothing there, but they'll get the $700. And again, it goes to the charity. So doing something like this, 99, if not 100% of the time, pays for itself, because you have to join the trust and there are fees to do that. But once you're in it and it's established, if it costs $1,500, let's say, to join the trust, in my example of the $700 spend down, after 2 months it's already paid for itself, because now you get to use that $700 for your bills, whereas otherwise you were using it on your care and you were living on $800. So I spent a lot of time on that, but I think it's important to know.
I have one question about that.
Sure.
Is that concept, which it's a terrific approach to cure a very large problem, but there must be an income level of where that is not even necessarily a doable approach.
Yeah, well, right, of both extremes. I think if you have the retired, policeman, fireman, teacher who might have $4,000, $5,000, $6,000 a month of income, unless they need a really high level of care. I mean, somebody like that, to me, I'm sending them to you to talk about long-term care insurance, because they can afford to get it, and frankly should at that level. Somebody at the other extreme who has $900 a month of income probably is not going to make sense to go through all the hassle of joining a trust for a couple of bucks. So it's really the person who has what I'll call a normal amount, because I think that those other people are rare, although they're probably coming more around as the baby boomers and all come around. So the typical people who have $1,000, $1,500, $2,000 a month of income and need every bit of that to survive is really the target.
Yeah.
But you're right. I mean, there are people out there who have nice income that it's just not going to work for them because they don't have enough bills to justify all that money going into the trust.
Exactly.
Yeah. Because it's use it or lose it. All right. So the house, the residence is typically still, I think, most people's most valuable asset, if not on paper, in their hearts and their minds. Because that's where the family grew up and it's very sentimental. So a lot of people want to protect their house. And when I say protect, the simple example of protecting anything, whether it's your house or money, is it's got to come out of your name. Unless Susan get you a nice long-term care insurance policy, then you got the deal is going to be you have to get things out of your name. And what I usually say is smart ways to do that are not so smart ways to do that. So when we're talking about the house, one of the ways that we do that is putting the house into somebody else's name, typically the kids, and you would keep a life estate. That approach is very common pre-2006 when the Medicaid laws changed with this whole 5-year rule and everything else, making things more complicated. So that's become less popular, although it's still an option. We can also do what are called exempt transfers, which I'll talk a little bit about in a minute. And then we can talk, we put houses into what we call a Medicaid Asset Protection Trust. And that, I think, by far and away is the most popular and probably the most valuable, aside from the exempt transfers, way to protect the house. So I think we've got a slide on that too. So here's some of the exempt transfers, and this is just for your home. It doesn't apply to liquid assets. So what we're talking about is taking the house out of your name where it does not subject you to a Medicaid penalty or waiting period. And again, we're only talking nursing home because there is no waiting period for home care. So transfers between husband and wife or wife and husband are exempt. So if a husband has a stroke and goes into a nursing home tomorrow, we can take his name off of the house, put it into his wife's name, and we're good. Child with disabilities. So if you have a child, an adult child, ideally, who is on Social Security disability, for example, then you can transfer your home into that child's name without the waiting period. You have to be careful here because I said Social Security disability, but if you have a child who's on SSI, also means that they're disabled, you can do it as well, but SSI has very strict rules. Social Security disability does not. So Bill Gates, for example, could go on, technically he could go on Social Security disability if he couldn't work anymore. I hope he wouldn't apply, but he could because he's paid into the system and he could go on disability. But he'll never be on SSI because the SSI is for people who are never able to work, and it's a way of providing a monthly check because they're disabled. And if you put a house or assets into that person's name, they could lose their benefits if it's done incorrectly. Transfer to a caregiver child. This is Medicaid basically telling your kids, look, live with your parents for at least 2 years, and if you take care of them, we'll let you keep the house. So it's kind of one of those quirky exceptions, but I think that's the rationale. So if you've had a child who's lived with you for at least 2 years, it has to be immediately prior to you going to a nursing home. So if you had a kid living with you for 40 years and they leave and then they come back and they're only there for 6 months and you need nursing home care, it doesn't work, right? So if the kid's out there and it comes home and stays with you for 2 years or it's never left, frankly, get a lot of stories about that one, then you can put the house into that child's name and it's protected. And the other one, which is also kind of not a quirky one, but it doesn't happen very often, except for maybe some of the people who have been in like Queens and Brooklyn forever, some of the families that just never left. The parents bought the house and the kids grew up there and they all lived there. You can transfer it to a sibling who's got an equity interest and has lived with you for at least 1 year. Kind of a weird one. So here's the Medicaid Asset Protection Trust. How are we doing on time? We're good. This is one of the best planning techniques that we have in our toolbox, as Vincent likes to say. So if you put your home into this trust, here are a couple of the bullet points. One is you retain the right to live there. I mean, that's always going to be the case. If you're transferring your home, you don't want to ever give up the right to live there. Even in the best of circumstances, people do funky things, so you want to make sure you're protected. Well, that's our job, but I guess to make sure you're protected. You keep your real estate tax exemptions. My clients would kill me if they lost their star exemptions, so we want to make sure that they keep their tax exemptions. there's some control over who the trustees are, who the beneficiaries are, because the Medicaid Asset Protection Trust is a form of irrevocable trust, and that word sometimes tends to make people a little antsy, I think, when you say irrevocable. So the way we tried to soften it is giving them a couple of strings. So they, mom or dad, or mom and dad, whoever sets up this trust, we're going to give them the right to change the beneficiaries anytime they want and change the beneficiaries anytime they want. So if you think about it, you're still controlling who's controlling the trust, and you're still controlling ultimately who's going to benefit. So it's got some nice perks to it. It preserves the capital gains tax exemption if the house is sold during your lifetime, protects the home from family issues. This is a big one because, as I said, pre-2006, it was very common to put the house into the kids' names because there was a benefit from a Medicaid standpoint in terms of shortening the penalty, which is no longer the case, which is why the trust is better. So if the house is in the trust, it's not owned by any one or more people. It's owned by an entity, which is this trust. So if anything happens, God forbid, to any of your family members, the children, for example, death, disability, divorce, lawsuits, we don't have to worry about it. It doesn't become everybody's problem because the trust owns the house. So it's more protective not only for you as the person setting up the trust, but also for your family. It avoids probate. That's just a bonus. That's not why you would set up a Medicaid. That's a protection trust because there are other ways to avoid probate if that's your sole goal. And then the sales proceeds are protected even if it's sold. So again, here, years ago, if we had transferred the house into the kids' names and you retained the life estate, if the house was sold during your lifetime, you would get some of the money because the life estate actually has a percentage of ownership based upon your age. Now, when we put the house into the trust, we put the house 100% into the trust, and the trust gives you the right to live there. So that if the house gets sold, all of the money goes into the trust. The most significant example of that is this whole 5 years. So if we put a house into the kids' names today, in 2013, in 2019, which is 6 years from now, the house is fully protected. But if the house gets sold, the parents are going to get some of the money because of the life estate, and that money is now going to be unprotected. Plus, the kids have to pay capital gains tax because most likely they don't live in the house, so it's not their principal residence. If the house is in the trust in 2013 and then 2019 they want to sell it, 100% of the money goes into the trust, 100% of the money is protected, and you keep your capital gains tax exemption. So there's really very little downside to this Medicaid Asset Protection Trust. Right.
But question,
Sure.
If that were the case and the parents have sold the house, the proceeds of that house are in that Medicaid Asset Protection Trust,
Yes.
Can they have any right to live off of those proceeds? Can any of those monies be used for expenses, i.e. living and or long-term care?
So I'll give you my favorite answer. It depends.
Okay.
Here's the deal. So usually when I talk about the trust, the first question I get is, yours is the second question. The first question I get is, can I sell the house? And as we know, the answer is yes. You can sell the house, no problem, but 100% of the money goes into the trust. My follow-up question to them is, where are you going? Right? Because if you sell your house, you're not living there anymore. So one of three things that I've come up with, unless somebody comes up with something more. You're going to buy something else, usually downsize or right size. You're going to rent, or you're going to live with somebody else, and they may or may not be rent. Right? And rent could be assisted living, it could be an apartment, it could be whatever.
Right.
So in the Medicaid Asset Protection Trust, you are not entitled to principal. It can't be used for you, it can't be taken out and give it to you in any way, shape, or form, because that would undermine the purpose of the trust.
Right.
Then there's income.
Right.
So when the trust gets set up, the conversation with the client is, if this trust ever has income in it, and it's hard sometimes for people to envision that, especially if they're just putting in the house. But you know, let's say, well, you say your house is $500,000, you got to put that money somewhere. It's going to earn money.
Yes.
Do you want that money? Do you need that money? So it's a decision that you have to make and live with. So more often than not, people will say no, they don't want it because they want to protect this much. Because if the income comes out, because you can say when you set up the trust, I know I can't have the principal, but I want that income in case I ever need it. That's fine. Just understand that if you ever go on Medicaid, the income is going to be unprotected.
Income is going to be treated or is going to be a determinant in terms of your Medicaid eligibility.
Correct. It can't be protected.
The asset, the principal would be protected, but not the income.
Right.
Okay.
Unless they say I don't want the income either. So let's
have to
say
stipulate that in the language.
when you start, right, when you set it up. So let's say we set up I don't want anything. There's a back door in the trust that allows the children / beneficiaries, because they're usually the same people, to take money out among themselves and give it to the parents. So it's coming from the kids, it's not coming from the trust.
Interesting.
All right, so if you were going to sell your house and move into assisted living and you needed some of that money to live on, we can backdoor it through the kids.
But that's interesting.
Yeah.
Okay.
Of course, if you have long-term care insurance that covers assisted living,
That's true, but if that income goes to the kids, then it's deemed taxable income to the kids.
actually, no.
Oh, that's an interesting,
Yeah,
okay.
the trust, the way the trust is set up,
Okay.
it's called a grantor trust, which is just an IRS term.
Uh-huh.
Whether or not the parents take the income, they get taxed on the income. When the kids, if the kids take money out of the trust,
But the
It's
scenario
an-
we, I'm sorry, the scenario we just described, they said, no principal, no
No
income,
income.
we sold the house,
Right.
this money's sitting there, it's earning income.
they're paying taxes on it even though they can't touch it.
Oh, they pay the taxes.
The parents is saying, right. Any money that comes out of the trust to the kids is
Yeah.
considered an advancement of their inheritance, so it's not taxed.
Oh.
It's a beautiful
right.
thing.
Well, yeah, yeah. It's beautiful, but something to keep in mind in terms of, can you deal with that too?
Yeah, oh yeah, yeah,
Yeah.
yeah, because not everybody wants to pay tax on money they're not getting.
Right. Okay.
All right, so now let's talk about liquid assets. That was basically all about the house. So a couple of points I want to make here. One is this gifts to family, which I have here. It's a $10,000 rule. It's in quotes. It's not a real rule, but most people still think of it as $10,000. This is the old, I can give my kids $10,000, which is now $14,000, by the way. It's changed over the years. So that's an IRS rule. So the IRS says that I can give 100 people $10,000 every year, and the IRS could care less about it. But if I end up in a nursing home within 5 years of having done that, Medicaid is going to be very interested in that, and they're not going to be happy with it, and they're going to penalize me for it.
Right.
So if you're looking to protect assets, what I refer to sometimes as true gifts versus conditional gifts. So a true gift is, here's $5,000, go on a cruise with your family. I don't know if that's enough to pay for a cruise for your family, depending on your family. Here's $10,000, get your roof fixed. I don't care what you do, I'm not expecting it back. A conditional gift is, here's $50,000, I want to get it out of my name to get that 5-year clock started, but if something happens, you better give it back to me. So Medicaid doesn't make that distinction. I'm making the distinction. So this $10,000 thing is just an IRS 14. It's just an IRS rule. It has nothing to do with Medicaid, which is usually when people say to me, so Frank, you're telling me I can't do what I want with my own money. That's what you're telling me. And my answer is no, you can do whatever you want with your money. Just understand that there are certain ramifications to doing it. So if you're looking to protect your money, we can take money and we can put it into the Medicaid Asset Protection Trust. We'll just set it aside. It can be in the trust and it'll just sit there. And we can get it back if we need to. Living trusts, revocable versus irrevocable. The point here is revocable trusts do not protect anything. And that's unfortunately, I don't want to say a common misconception, but more people out there that think that revocable trusts protect assets when they don't. And I think, frankly, that they may have gone to presentations and been sold kind of a bill of goods because Susan is nodding. I can't see you.
You can't see me, but I will tell you, folks, underline that and put it up on a neon sign. I've been with more people, and they say, I took care of everything because I put it into a living trust.
Right.
I say, revocable or irrevocable? I don't know,
Right.
but I just know.
Yeah.
Well, it's not the word living trust. It's what it's
Right.
the term is really was it revocable or irrevocable. Very, very important.
Yep. Yeah, I've had to undo a bunch of revocable trusts for clients because they thought that their assets were protected. So it is what it is, but just know that that's not done. Revocable trusts are done to avoid probate. They're not done to protect assets. Exempt transfers, similar to the house, you can transfer assets, because we're talking about money now, liquid assets. You can transfer assets between spouses. You can transfer assets to a disabled child. So those are a couple of the exceptions. And then retirement accounts I just want to mention because retirement accounts are interesting when it comes to Medicaid because retirement accounts are, and I'm talking about IRAs, 401ks, 403bs, these are money in the bank, so to speak, so you can look at it as an asset, but once you hit 70 and a half or even 59 and a half, you can without penalty, you have to start taking money out, and that's income. So if I need somebody to apply for Medicaid, let's say I have a $100,000 IRA, does that count towards my $14,000, or does the money I'm pulling out count towards my income? So the simple answer is you can decide. You decide once, or somebody will decide for you if you can't. if you're applying for Medicaid, you have to make a decision of how you want Medicaid to treat that. So I could have somebody who has a $100,000 IRA and $10,000 in the bank and be on Medicaid. And the trade-off is that distribution that they're taking out is income, and depending on if they're married or not, if it's Medicaid, home care versus nursing home, will determine what would happen with that income. If the option is to cash in the IRA, which goes against all rational thought, because it's beat into our heads all of our professional lives that save, 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 defer, 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 and now here I'm saying cash it in. I'm not saying cash it in, I'm saying it's an option. Sometimes it's a viable option, so I'll give you a quick story. I have a client, clients of mine who came to me at what I'll say is a young age, because most of my clients are older. They were in their 50s. But the reason that they came was because he had just been diagnosed with early onset Alzheimer's. So he was 52 or 3 or 4, somewhere around this. This is a number of years ago. He was still working. I mean, it was fine. We did wills and all the basic stuff. So anyhow, long story short, after a few years he couldn't work anymore. By the time he was 62, he was in a nursing home, and is to this day, unfortunately. So when he had to go to the nursing home and I was meeting with his wife, we had moved things into her name because those were all exempt, and then we're left with this 401k of $360,000. So I said to her, look, here are your two options. You can cash it in, but don't do that without speaking to your accountant first, so you're going to tax it. But if she cashes it in, because it was the wife, she could take the money and put it into her name, and that's one of these exempt transfers, and she can move on with her life. Or we can figure out how much income he has to pull out, and based upon her situation, that income would have gone to the nursing home because she already had her own income to live on, so she wasn't going to get any of it. So he was 62, 63, whatever it was, and physically healthy. So now you're faced with the situation, well, if I cash it in, and he dies a year from now, 2 years from now, then I made a bad decision because as the beneficiary, she would have inherited it and could have spread out the payouts and all the other business and not pay this big chunk of tax. If I go the other route and he lives too long, by pulling money out and give it to the nursing home every month, he may outlive the money and the money will be gone anyway. So she made the very tough decision. She cashed it in after speaking to her accountant. She ended up paying close to $50,000 in tax.
Probably.
So she took the $300,000, put it in the bank. We got him on Medicaid. That was 4 or 5 years ago. He's still in the nursing home. He's still on Medicaid. So far she's made the right decision. But unfortunately, it's one of those things where you have to make it's a bet to die decision that you're kind of making in the moment. There's no way of knowing for sure. You just make the best decision with the information you have, and you have to move on. You can't dwell over whether it's right or wrong. But it's a tough one. But it's an option. That's the point. We don't do advanced planning with retirement accounts. Living trust. So here, this is a bit of a repeat, I guess. Revocable living trust, as I said, don't protect assets. You have full control. It's your own money. It's really done to avoid probate. And then the irrevocable living trust, which is the MAP trust, we call it Medicaid Asset Protection Trust. We've got the 5 years, so if you put assets into the trust, you have to stay out of a nursing home for 5 years before you're fully protected. Here's what you were asking about, Sue, when we're talking about the income. You can retain the rights to the income, but then it's unprotected. And you've got some control, again, because you're controlling the trustees, you're controlling ultimately who the beneficiaries are. All right, this is the IRA account. I think I already talked about this, so I'm going to skip over this because we talked about it's an asset or it's an income, and there are tax implications. Always speak to your accountant. Planning in advance is our preferred method. We do not like, although we're perfectly willing and able and capable to deal in crisis situations, but very few people like to work in crisis. I think it's much better to work when things are calmer and you're not faced with the conversation I had tonight with a woman who, I spoke to her last night. She happens to live upstate. Her dad and mom are here. Her mom had an aneurysm 2 weeks ago. She's still in a semi-comatose state. And they're coming down to meet with me on Monday to talk about, what's hopefully, they're not sure what's going to happen yet, but talk about their options. She called me today to say that the social worker from the hospital said, well, we're planning on discharging your mom next week. And mom was out of it. She's like, where did this come from? Well, I said, well, that's what happens. I mean, now you're in crisis mode. So it's, unfortunately, I think they've done a couple of things, a couple of basics, hopefully, at least. But now they're going to be faced with this stressful environment of having to move things quickly and do all kinds of things under stress. So planning in advance, and sometimes you can't control this stuff. I mean, but at least get the advance directives in place, get your wills in place, because at least with those we can do pretty wonderful things, frankly.
If I could just interject,
Sure.
planning in advance. So this particular case, how old is this woman that unfortunately now had the aneurysm, and the daughter is?
I want to say she's young. I mean, young. She's in her 70s.
She's in her 70s. So the daughter, I assume, is in her.
There are actually
early
4
40s.
daughters. Yeah, so I think she's probably around there.
Okay. So what I want to point out to everybody on the screen is that very often we're talking about these scenarios where there's more older people involved and planning in advance. So I would like to impress upon everybody on the webinar that look at this screen with the elderly couple and the younger daughter.
Right.
This daughter is probably facing and helping her parents plan, but as much as she's trying to do something with her parents, the children fail to even plan in advance for themselves. So this problem perpetuates itself. That daughter should be in the planning mode just as much as she's trying to convince that couple to plan.
I couldn't agree with you more, because that's, unfortunately, those kids, they don't plan until something happens in their family, and it's usually to the parent or something. So you're right. I mean, I'll meet with the family, and a lot of times the kids are sitting there at 40, 50 years old. It's an eye-opener. Wow, I don't have a power of attorney. Maybe I should do one.
Absolutely.
Maybe I should look into long-term care insurance so they don't end up in this crisis mode where I'm spending all this money for lawyers and everything else. Right.
We unfortunately have adapted, which is a healthy posture, is that we're too young, we feel good, nothing's wrong, we have time to get these things straightened out.
Right.
And unfortunately, the failure to plan ahead, regardless of your age, is a plan for failure.
Hire a teenager. They know everything, right? Oh, look at that. So now they can see you. So I want to turn the microphone over to Susan for a few minutes, and I may interject as well as
Absolutely.
as Susan did. So I'm not going to read. You can all see some of Susan's credentials, and you can see she's licensed in multiple states. She's also certified for the New York State Partnership, which hopefully you'll mention that as well, because I do get a lot of questions about that. But I think the thing is, the important part is that Susan's an independent insurance agent. So she is somebody who not only knows her stuff, but can sell you a multitude of products depending on what's right for you, right? So and we've had a great relationship with Susan for a number of years, and Susan has served our clients fantastically when we've been able to convince them to talk to you, because it's hard, just like us. The hardest part of my job is getting people to the table to talk about this stuff.
Sure.
Right. So,
sure. Absolutely.
And everybody wants to know what it's costs, and everybody has this thing that lawyers are too expensive, insurance is too expensive, and all these other business. So hopefully you'll address a little bit of that too.
Okay.
So go ahead. The floor is yours, Susan. Thanks again for being here.
Oh, it's a pleasure. It's a pleasure. And let me just say before we get into the options and the points on the screen is that as far as I'm concerned, I did go through a long-term care situation with my father many years prior to even getting into this professionally. And the one lesson that I took away from that is that there was no plan, and I was totally vulnerable as being the decision maker for my father's finances, which had to be dealt with at the worst time in the market. So if I had had a plan, and I'm not saying insurance is always the plan, but if I had, and we've given this some thought, that possibly the decisions I was forced to make in crises would have not been the case, and I could have made better decisions given a better time in the market financially to spread out the use of his resources. So I speak from experience, and having then spent it down, having gone through the Medicaid application process, and that was many years ago where we didn't have the Frank the Quickiest to go to. We had to do it on our own, fill out the application, bring all the paperwork to the social services, and it was not easy. Very challenging.
Yeah.
Very challenging. So let's get into the slide and the options, and some of these have already been touched upon. So we'll be clear that, first of all, just a quick definition. Long-term care is really a situation where something physically has happened to you. It doesn't matter your age. It doesn't matter why. It doesn't matter the fault of. It's about the idea that physically something has created you to be physically debilitated, that you can't properly take care of yourself. So presumably everybody on the call, and we are here in the office, we bathe and dress and toilet, and we can move independently, and continence and eating and toileting. But when those are challenged, either for a temporary situation, which could be medically related in terms of recovery, or an accident related in terms of recovery, or something of more chronic diagnosis that it's ongoing, being aging, or a disease-related issue, that when you can't properly take care of yourself and you need the help of another human being. And if it weren't for a physical need, it would be a cognitive need, obviously Alzheimer's, dementia. It could be a byproduct of a medication or a diagnosis. So when this arises, the question of, here we've been discussing tonight, what are the options? And when you talk about health insurance, Frank has already touched on it, and you talk about, I even put workman's compensation in there. Workman's comp, disability, health insurance. Health insurance is designed to help treat, diagnose, treat, and rehabilitate. They do not give you ongoing care either at home or an assisted care facility or nursing home. That would be independently handled. Workman's compensation disability is simply put in place for those people that are working that become disabled temporarily or more permanent, to provide for replacement of income. It would not extend itself to providing for the needs of this care.
So can I ask you a question?
Yes.
Is it, because somebody used this term with me before, in terms of tapping into the insurance coverage, they use the term hands-on. So is it something where it has to be hands-on, right? Yes?
No. Okay. The good question. They call it standby assistance and you call it hands-on. Standby assistance means that you might need the assistance of somebody getting out of the chair, getting out of bed. You could do it, but it would be safer if somebody was standing by so that you wouldn't lose your footing and fall, or if you're trying to put on your pants, or you're trying to put on your shirt, that somebody is giving you some assistance just to help expedite it and keep you safe. Hands-on means that you literally need somebody to physically take charge of every physical action, getting you out of bed, helping you into the shower, getting you to sit in a chair, helping you to be mobile in a wheelchair or whatever. So regardless of its hands-on or standby, the custodial determination, the definition of custodial means that you need help because you've got this physical challenge. Dementia, Alzheimer's, some people can be physically independent and they can get themselves dressed, but they wouldn't remember what they're going to do after that. So that is more of an assistance of someone giving them guidance and making sure that they're safe and taking over responsibilities that they obviously could not handle due to failure of memory, driving, cooking, doing their bills, and maintaining themselves in their home properly and independently. Okay. So now we talk about Medicare. There's no magic to Medicare. There is a presumption out there that it is, but folks, if you're 65 and older, if you're already on Medicare with a good supplement, which presumably you do have, it's health insurance. That's all it is. There's no magic to it. The only time it would step in is that if you were transferred from the hospital, and having been 3 days in the hospital, to rehab, which is generally in the same facility that on the outside it's called nursing home, but they've allocated a floor or two to rehabilitation. That's where you're getting rehabilitated to come home, to continue, and that's where you could have a combination between Medicare and your supplement, assuming you have the correct supplement. Not everybody does, but that should give you on par about 100 days coverage. After that, if there is no medical improvement to your rehabilitation, that support for Medicare and your supplement stops, okay? And then you're on your own.
I think it's important, sorry to interrupt, Susan.
No, not at all.
That I just want to hammer that point home because I've spoken to people where they say, well, I get 100 days. And I said, well, no, not necessarily. And
No.
I said, yeah, my supplemental covers 100 days. No, not necessarily. When Medicare stops, your supplement stops. And that could be 20, it could be 42, it could be 87, whatever it's going to be.
It's really the definition, because the definition is supposed to be medically related.
Right.
It is not custodial related, it's medically related. So if you're there to be rehabilitated from heart, stroke, hip, joint, knee, whatever, is that there is a protocol in there of how long they think it will take you to rehabilitate from that problem. If they've gone to the max and you still haven't fully rehabilitated, they're not going to continue to support it. They're just going to disengage, and that's where it becomes your problem.
Right. Now you're moving into private pay, or if you have insurance,
Exactly.
or Medicaid. Right.
Exactly. Okay. Now we've got Medicaid, and of course we've spoken about that throughout the presentation about the challenges there. Medicaid, in the true definition of long-term care, was designed for people who are financially debilitated. All right? And yes, you can make yourself eligible through planning and divestiture and look back and so on, and we've discussed those at length tonight. But, you know, that is not the first resort. That is an option, and it's not necessarily designed for everyone. And you have to look at that, and you have to look at the timing of it. And then if you talk about self-insured means is that, yes, Susan, I agree that this could happen to me, but if it would happen, and I needed care either at the choice of home or assisted care facility or nursing home, I am perfectly comfortable with the idea that I would be financially liable for it. So let's talk about what is that financial liability. If you're talking home care on today here in this island, you've got to figure anywhere between $15 to $30 an hour. If that person were with you for 8 hours or persons, that's $120 to $240 a day. And that would be on average over 365 days a year. That'd be between $45,000 to $88,000 a year. So that's what you got to be prepared to write the check out, and you have to be prepared to write it out every week or every day. If you're talking about assisted care facility, that is a monthly charge, and that's anywhere from about $7,000 to $9,000. And there's some assisted care facilities that could be as much as $10,000 or $12,000. Your nursing home is $375 to $450 a day. The math is six figures, $137,000 to $175,000.
Piece of cake.
So when you talk about self-insured, that's today. And if you're not happy about writing out that check or writing out multiples if it were care needed for 2, 3, 4, 5 years, then you don't want to be self-insured. That's not an option. Okay, long-term care insurance. It is a plan. It is insurance. It's designed to be put into place to help offset the financial risk of care, whether you choose to be in either home, assisted care, or nursing home. The carriers are not imposing upon the venue, and they're not imposing upon who you have to hire in the home or the choices that you make. That will be dictated probably either by your family who's managing the issue and or what your physical or cognitive needs require in order to make you safe and comfortable. So the insurance is really the fallback, or I call it, if I could say, it keeps the devil at the door to give your family an instant resource to help deal with this problem until they can find out or figure out, if possible, just what kind of a challenge is going to be ongoing, depending upon whether your situation could be temporary or it could be chronic. Could it be handled with home care and eventually transitioning to assisted? Is it going to be more catastrophic that home care is definitely not the case and you're going right into, or the person is going right into the nursing home? So it really gives the family the tools they need to make better decisions depending upon how long this is going to be as far as a challenge and what the financial challenges are going to evolve into depending upon the need.
Makes that crisis planning
Definitely.
a little less onerous because you can actually breathe because you've got a source of payment to cover at least some amount of time where you can get your ducks in a row.
Right. That's exactly right. And for many people, too, that say to me, well, Susan, I've got several pieces of real estate. That's great. On paper, that's a fantastic asset. You cannot sell real estate in an instant. You can't take the person and say, excuse me, sit over there, wait until I get this transaction done,
Right.
and then we've got all this money, we'll definitely fund the problem. That could be, but you can't put a long-term care or care scenario on hold until you've
Right.
done that. And it may be also the worst time in the market, and you don't want to do
Right.
it then. Okay? So, two last options, and I want to move it along in respect to everybody's time. The New York State Partnership for Long-Term Care was a plan that was designed at the state, and they wanted to help literally people protect their assets if they headed into long-term care. So it is a plan whereby the state has married with a number of insurance carriers with a specific plan design that if the policy in place is paid out the benefit for a period of time. When that comes to a conclusion, you're eligible to apply to the state for Medicaid subsidization based on income only. Assets are protected. All right. Now, I know that's a mouthful, and you're thinking, now, what the heck did she just say? So I have to respect the time. It's a tool, folks. That's what it is. It's a tool. Any one of these on this option sheet could be a tool from Medicaid, planning, self-insured, long-term care insurance, New York State partnership, and last but not least, this is another tool, the hybrid plans where it's life insurance with a long-term care insurance rider or life insurance with an accelerated death benefit that you could use what otherwise would pass at your death could be used to pay or support a long-term care problem. So I want to impress upon everybody on the phone or whom you may speak to or maybe speaking to your kids, there is no easy fix or answer. The best message I could deliver to you this evening is either talking to a Frank, or you want to talk to me, Susan, you want to talk to a qualified person that can give you directions and work through the options to find out what is the best approach for you to handle the plan either currently, if that's what's on the table, or be in advance of the plan and plan for the future.
And I want to point out that Susan's information is on the screen and it's been up there. So hopefully, if you have any questions, because yeah, we're kind of pressed against time. We only have about a minute left. So I want to respect the time frame that we put in. I want to thank again Susan for coming and spending time, but I'm sure she can go on for a lot more with all the information she's got. So her phone is there, her email is there. Please feel free to reach out to Susan directly if you have any questions about the insurance or any things that she talked about. You can always, of course, reach out to us here. I don't think we're going to have enough time for any questions.
Do we have any questions?
I just checked a minute ago and there weren't any. So
okay.
If anybody does have any, let me get to here's our information. So you can email us or contact us directly with any questions about either what I talked about tonight or anything else, frankly, that's relative to this subject. So again, I just want to really thank Susan for taking the time out of her day and an evening, more importantly, where she could be home with her family.
Oh no, I think this message is so important, what we're trying to deliver, and I just wish more people would take advantage of situations and webinars and other seminars that are offered to start to get the information so they get the facts.
Yeah, because there's a lot of misinformation out there. That's the problem.
And people base their decisions on misinformation.
Wrong information, that's right. So again, thanks Susan, and thank everybody for participating tonight with the webinar. If you have any additional questions, you can email them to us at info@vjrussolaw.com. As Susan mentioned, we continually do the seminars and the webinars. You can check that on our website, which is there on the screen. And as a reminder, please take a minute to fill out the survey that is going to pop up when the seminar ends. Your feedback is really helpful. We do read the feedback, and we base our future programs on the feedback that we get from you all. So thanks again, everybody, and have a great evening.